This court is now resumed. You may be seated.
Good afternoon, Dr. Von Gernert.
Good afternoon, Mr. Shaxter.
We're going to be talking a little bit now about your perspective report, Exhibit 50, I believe. I wonder if you could have that in front of you, if you don't mind, and if you could turn to page 28.
I'm sorry, page.
28. So page 28, if you is part of your opinion on sharing based on assumption, what you call assumption number 2,
Yes,
which is your attempt to capture what the Court of Appeal actually decided. Yes.
yes,
Now on page 28 in the the first full paragraph, starting with, so what might be the potential role? You see that
yes,
paragraph there? Here you're questioning what the potential role of Anishinaabe principles, perspectives, understandings, and expectations might be in relationship to what you call the shareable excess. See that?
yes,
And although you say that it's in the realm of speculation at a high order of magnitude, I want to put those aside for a moment, because I have a question about the next major sentence, which is, if the option is available and it serves their interests, humans will often, but by no means always, seek the most that they can get. And so my first question is, when you say use the subclause, the most that they can get, do you mean the most that they're properly entitled to? Or do you mean the most that they can trick someone into believing they should be entitled to? Or do you mean something else? What do you mean by the most they can get?
the most that they can get, whether they are entitled to that amount through any other standard or not. Right, so whether they're, I mean, if you present an option that they can get a certain quantum, humans will, no matter what culture they come from, often, but not always, and I qualify that with not always, attempt to obtain the maximum that the option provides for them. Now, obviously, that's very much circumscribed. If, for example, they are not legally entitled to a particular portion under some law, then most humans will actually abide by that. If they're law-abiding citizens, they're not, but there are, of course, criminals who will not abide by that, right? So,
but Dr. Von
Gernert,
in the context in which you have used that phraseology in paragraphs 27 and 28, I'm going to suggest to you that you are suggesting that the Anishinaabe are seeking to interpret the facts in a manner that would maximize the compensation to be paid in this stage 3, regardless of what you say are the facts. Is that fair?
no, in this instance, what is a fact is that the Court of Appeal it says that during arguments presented in stage one, both the Huron plaintiffs and the Superior plaintiff suggested that a fair share would be 100% of net crown revenues. That's, unless that's disputed, you know, my comment, it must be taken in that context.
Sorry. So are you, I guess what I'm not, I'm gonna return to it. When you use the phrase, the most they can get, is it fair for me to say what you mean to say? They will often, but not by no means always, seek the most they can get to which they are properly and legally entitled to? Can I add those in? Is that what you meant?
Yeah, I think that in this context would be fair, yes.
And you would agree with me that there's nothing wrong with people asking for that which they would be properly and legally entitled to?
If they thought they were properly and legally entitled to that, yes, but then the whole point of my paragraph is that if everyone agreed that they were properly entitled to 100%, then there wouldn't be an issue here. But there is an issue, as far as I understand it, in that there has to be a quantum that this court has to opine on, which is somewhere less than 100%.
That wasn't my question.
Yes, but that's
You-
the context of my paragraph.
All
I
right.
wouldn't mind if you'd answer the question though.
So can you repeat the question?
Well, the question is simply that there is nothing wrong with the Anishinaabe in this phase 3
Yes,
seeking the most that they can get to that which they are properly and legally entitled to. You'd agree with that?
yes, I do.
I want to turn to page 29 of your perspectives report. Now, at page 29 of your perspectives report, you opine that treaty commissioners did not meet cultures on the other side of the council fire, but individuals who had varying perspectives, understandings, and expectations. Do you see that there?
Yes,
That's at the bottom of the first, 4 lines from the bottom of the first page. First paragraph. Yes, you see it?
yes, I do.
All right. So can I call this, just so that I don't have to repeat it every time we talk about it, a fundamental assumption of yours? Is it fundamental to your opinion?
Yes, to the extent that it's a truism in anthropological thought that you never meet cultures, you meet individuals within cultures.
So it is fundamental to your opinion in your perspective reports that they meet individuals, not cultures, right?
Yes,
So would you agree with me then, sir, that everything that you have to say about Treaty 3 and Treaty 9 cannot tell us anything about what happened in 1850? Wouldn't you agree with that?
no, that would be overgeneralizing it.
Maybe I can try it this way. Who at Treaty 3 was present in 1850?
There were individual chiefs and headmen and other members of the community. The leaders who were recognized were either purported to be or themselves purported to be representatives of the First Nations who became RHT and RST signatories.
No, sorry, I maybe you didn't hear my question, and I'm going to turn it into a more leading question. I'm going to submit to you that none of the people who were present at the negotiation of Treaty 3 were present in 1850 when the Robinson Superior Treaty was negotiated.
Oh, I'm sorry, I misunderstood.
Yes.
You're talking about Treaty 3? Yes, there's nobody at Treaty 3 who attended
Okay.
the.
And the same
1850.
goes for Treaty 9. There's no one at Treaty 9 who was present at at the Robinson Superior Treaty of 1850.
No, but there was a chief of an RST chief who was present at the time of the 1905 negotiations in Treaty 9. He was not a signatory to the Robinson Huron Treaty, but he was an RHT chief.
He was an RHT chief.
Yes,
Okay, I asked about RST.
I'm sorry, he was a. Yeah, I honestly don't remember if it was an RHT or an RST
Do you
chief.
remember his name?
Well, it's in my report somewhere. I don't recall his name, but either way, he was a Robinson Treaty chief who was present. He was not a signatory, but
No.
he was present and gave a speech.
He wasn't a signatory to Treaty 9.
Yes,
You don't know whether it was Robinson Huron or Robinson Superior. You can't remember whose name it is.
it's in one of my reports.
Okay,
It'd be easily found.
okay. Why don't we'll ask someone else to look for that if we can. But in the meantime, let's stick with Treaty 3 because
Yes.
much of your report is really comparing Treaty 3 to the RST Treaty of 1850, right?
Yes,
Now, I'm going to put it to you, sir, that what happened in Treaty 3 according to your theory, involved varying perspectives, understandings of individuals at Treaty 3 who were not present at the Robinson Superior Treaty. Would you agree with that?
absolutely.
So you can learn nothing about the perspectives, understandings, and expectations of the Robinson Superior attendees from what the Treaty 3 chiefs and headmen believed. Do you agree with that?
That was indirectly my point, because this whole discussion was a response to Dr. Driven. And it was Dr. Driven's premise that we should be able to understand Anishinaabe perspectives in 1850 if we understand Anishinaabe in general. And my
I'm asking
point
for
was
your
the
opinion, sir, not
opposite.
Dr. Driven's.
Yeah, well, mine is in response to Dr. Driven.
But I wouldn't mind, sir, if you would listen to the question,
Yes,
answer the question, and if you wish to add something, please do.
okay, so what is the
But
question?
yeah, so you don't know what the question was. That's the problem.
All right. The question was that what the individuals who negotiated and concluded Treaty 3 understood about their perspectives, understandings, and expectations in Treaty 3 in 1873 tells you nothing about the perspectives, understandings, and expectations of those persons that negotiated the Robinson Superior Treaty in 1850. Is that true?
I don't think it tells us nothing. The Anishinaabe in 1873 well, let me rephrase that. that if the question is, you know, when we look at the 1873 treaty and the actors that were negotiating at that time, whether what they were doing tells us nothing about what the actors in 1850 were doing. Well, of course, the actors in 1850 didn't have the benefit of anything that happened after 1850, right? So it is literally impossible for them to know in 1850 what other Anishinaabe leaders were doing in 1873, right? Although the reverse is not the case.
All right, so can you tell me, sir, how it is that your fundamental assumption that the commissioners did not meet cultures on the other side of the council fire, but individuals who had varying perspectives, understandings, and expectations help inform, if that's your theory, that's your working theory, that's your assumption. If that's true, I put it to you, sir, that anything that any of those chiefs, headmen, principal men may have believed, understood, or whatever their perspectives, understandings, and expectations may have been in 1873, it can tell you nothing about what the perspectives, understandings, and expectations were of the Robinson Superior Anishinaabe. Do you agree with that? About what they believed in 1850?
Yes, I wasn't trying to suggest that would be the case. It was, I think you're right. I mean, it when put that way, that's exactly right. And it's for that reason that you can't use general assumptions about Anishinaabe culture to try, taken from all kinds of sources, to illuminate the specific events in 1850.
This is your theory, working theory. I'm not
Yes.
saying I accept it. I'm just trying to understand how helpful your opinion is if we follow your opinion. So Treaty 3 doesn't help us in terms of understanding the varying perspectives, understandings, and expectations. How about pre-1850 treaties? Would you agree with me that since, on your theory, since they're only meeting individuals with varying perspectives and understandings and expectations, what was negotiated prior to 1850 by other individuals, other Aboriginals, other Crown actors cannot help us understand what the perspectives and understandings and expectations are of either the Anishinaabe or the Crown in 1850 at RST. Would you agree with that?
Well, that's a different scenario, because now you have at least the theoretical possibility of knowledge in 1850 of events that happened prior to 1850. And we know, for instance, that Chingwakons knew perfectly well from previous experience with his kinspeople in the South, both in the American side of the border and in Upper Canada.
I have to apologize, I think, because maybe I didn't make myself clear. I'll try again. I'm not interested. I agree with you that whatever Chingwakons may have known, whatever his understanding may have been, whatever his perspective was, and his understanding and his expectations, it may have been formed on his knowledge of what took place before.
Yes.
My question was directed to, we can't look to the actors in 1818 or 1827, according to your theory, to try and gain any insight into what happened in 1850. You agree with that?
Yes.
Thank you. Now, I want to talk a little bit about kinship. Could you turn to tab 2 of the compendium? That's Exhibit Q. Have you ever heard of a fellow by the name of Irving Hollowell?
Yes, of course.
Why do you say a yes, of course?
Well, he's well known as an early anthropologist who worked among Anishinaabe peoples, primarily in what is now northwestern Ontario and eastern Manitoba.
All right. So could you turn to page 16 of the compendium? On the bottom right-hand side of every page, there's a page number, and that will help direct you to the page 16.
Yes.
And this is part of Hollywell's publication entitled The Ojibwe of Barons River, Manitoba, Ethnography into History, A. Irving Hollowell. And it looks to be published copyright 1992, but he obviously wrote it before that since he passed away in 1974.
Yes.
Okay, so are you familiar with this book?
Yeah, I have it in my library.
Okay, so do you recognize this document?
I recognize the book, yes.
Okay, and you recognize this as being excerpts from his book?
Yes. I
All
do.
right, let's turn to page 16. Under the heading Kinship Patterns and Social Organizations,
Yes,
I want to read a passage and see if you agree with it. And I'm reading from the paragraph that starts because, which is the last full paragraph on the document.
yes,
Okay. Because the use of the native language continued, kinship terms were still used in the traditional way to address and refer to other persons in daily life. They functioned as direct guides to interpersonal relations, since customary attitudes and patterns of social behavior, including sexual and marital relationships, were implied in the use of them. Consequently, kinship terms were not merely a device for specifying the relationship of persons, but were also a means by which the normative orientation of the self in a traditional system of socially sanctioned roles and values was achieved. I'm going to stop there. Do you agree with what he said there?
yes,
I'm going to continue. The Ojibwe are an example of a now generally recognized principle. Kinship terms have a socially adaptive function as a signal system for discriminating among customarily distinguishable social positions, statuses, and roles in human societies. Let's stop there. Do you agree with that?
yes, they often do.
Next, continuing. In the socio-cultural system of the Ojibwe, kinship terms functioned as a means of promoting orderly social interaction within the context of interpersonal relations in localized groups, as well as with respect to the interaction of individuals belonging to different groups. Stop there. Do you think that's accurate?
Yeah, I think that's fair to say.
And would you agree that that is accurate to say with respect to the RST Anishinaabe?
I would venture to say that that's true of most, but perhaps not all human groups. Yes.
Okay, but I asked you about the,
Yes.
just about the RST Anishinaabe.
Yeah, I would include them.
Yes, thank you. He continues on, from childhood on, kinship terms oriented individuals' behavior in a social world that embraced members of their extended family, their social interaction with persons primarily affiliated with other groups, and as we shall see, relations with other than human persons or spiritual beings who appeared in in dreams. Kinship as part of the common linguistic and cultural heritage of these Indians provided the means of structuring their relations with each other wherever they were. Do you agree with that?
Yes, it's in accord with my own understanding that's gleaned from all kinds of sources other than Anishinaabe as well. So I don't know the specifics of the kinship system among the RST, but I would not be surprised if it was similarly constituted as most Indigenous peoples that I'm familiar with.
I'm going to turn to paragraph 47 of the trial judgment. And I want to read you a paragraph and see if you agree with that. At paragraph 47, the phase 1 trial judge, Justice Hennessy, wrote, in 1850, kinship metaphors were still very much relevant and defined the expectations, perspectives, and understandings of both the Crown and the Anishinaabe in respect of the making, interpretation, and implementation of the Robinson Treaties. See that?
Yes.
Do you have any problems with that? Do you agree that that's true?
I think the use of kinship terms permeates much of the discourse between natives and newcomers, including between the Anishinaabe and the Crown in 1850.
I'm sorry, you use
Yeah.
kinship terms. I use the documents as kinship metaphors. Do you understand there to be any difference?
Well, unless the metaphor is actually stipulated, I'm not sure what is meant by it. Certainly the kinship terms are used and are prominent. What they actually mean or what they are metaphors of is something we'd have to explore.
Well, I don't think we have to explore it. I think the judge maybe found it in phase 1. Let's read on. Continuing on with paragraph 47. In the context of the negotiations of the Robinson Treaties, the use of kinship terms served as a diplomatic formality, which was not, however, divorced from the underlying metaphors that accompanied kinship terms. Although the Crown and the Anishinaabe came to the negotiating table from different worldviews, there was a reciprocal use and understanding of kinship metaphors. You see that?
Yeah, I'm not sure that there was a reciprocal understanding. There was certainly a reciprocal use, but how those kinship terms were understood by the parties, I'm not so sure that there was complete understanding. Certainly the Crown didn't mind the implication that the Anishinaabe were somehow dependents in that sense of using the term children. I mean, that's a paternalistic attitude that, you know, the Crown had throughout the 19th century. But whether it was understood in the same way when the Anishinaabe used the terms father and children, I'm not quite so sure.
Would you agree with me that your opinion in both your reports before this court in phase 3 do not accept as true the facts found in paragraph 47 that I just read to you? Do not accept as true the facts set forth in paragraph 47 of the trial reasons, excuse me. Would you agree with that?
Well, I render my independent opinions according to my anthropological and ethnohistorical training.
I'm not quibbling
So,
with you on
I
that. I'm just asking whether you agree with it in your opinion. And I'm suggesting, I don't think you did. Would you agree with that? I mean, it's okay to have your own
Yeah,
opinion.
perhaps,
ask you to give each other a moment, because you're starting to overlap.
I apologize. Dr. Von Gerner, go
yes,
ahead.
perhaps I, as I just qualified my answer, to the extent that it's a qualification, I disagree.
Thank you. Would you agree with me that in the context of your opinion, the use of kinship metaphor, kinship terms was simply as an exercise in polite formalities, greetings, and nothing more?
In many cases, it was actually an extension of a centuries-old practice of formally addressing the other party.
But not in the metaphorical way of understanding relationships that the judge used it in paragraph 47 and Dr. Driven used it in his report, right? There's a difference of opinion.
Yes, primarily in respect to the Anishinaabe side of its usage.
Thank you. Perhaps we can go to page 5 of your perspectives report. And we can deal with the following. At page 5 of your perspectives report, under the heading Assumptions Adopted in Preparing this Report. I'll wait for you to get there. It's your perspectives report, not your slide. Not the slide deck, the perspective report, if that's what you've got.
Okay, what page?
Page 5.
Yeah,
I'll wait for you to get there.
I'm there.
All right. What you write is, given the wording of my mandate, I must necessarily diverge from my usual practice of considering only historic primary sources. And first, focus on a Court of Appeal decision. I'm not going to read the rest, but
Yes,
I'm correct, sir, that you do not, in your 2 reports, make any use of literature or scholarly articles that might inform you about Anishinaabe culture in 1850. Would you agree with that?
this is a report that is addressing, it's a reply report to others, and to the extent that I needed sources to reply, I included them in my report. If they do not include material specifically on Anishinaabe perspective, it's only because that was not necessary to the reply. There's a great deal in the Driven and the other 2 reports that I looked at, which I have no problem with. And so there was no need to address it. I was very specific in what I was addressing.
Again, I don't think you listened carefully to the question. You have 2 reports in this court case,
Yes,
or in this phase, I apologize, 2 reports in phase 3.
yes.
In neither of those reports, is there one citation of anything other than primary source documents? Do you agree with that? I haven't made an argument or anything that there's anything wrong with that,
Yeah,
but I mean, I'll make that argument later, but I'm suggesting to you that there isn't any.
let me start with the Just Demand report.
Go ahead. You have it in front of you. You can take
Yes.
as much time as you need.
So I resorted almost entirely to the primary sources. That, I mean, if I had done the reverse, I'd be accused of not doing actual ethnohistorical research.
I'm not accusing you yet,
Yeah,
sir.
so there is no secondary source material in that, and there's no need for it. It is all primary sources.
Thank
As-
you.
As for the second report, the perspectives report. This is basically a reply report to other experts. And more specifically to methodological and logical issues that I have in their arguments. And that did not necessitate going into a wealth of secondary source materials. Those points can be made solely with the materials that I cited in those reports. And every opinion that I have is footnoted.
You might note that I didn't ask you for a rationale. I was just simply trying to identify whether you made reference to any literature or other scholarly articles to inform you about Anishinaabe culture in 1850. And I think the answer is no.
Well, I haven't finished my answer to the second report with respect to the second report.
Go ahead,
In the
sorry,
second-
I apologize.
Yes, in the second report, of course, I also cite scholarly material. For example, Christopher Bexey,
Where's that?
page 36, footnote 50.
Okay,
I mean, I just opened the page and that popped up, so that's. I'm not saying that there's a lot of them, but it's not as if I didn't cite any scholarly or secondary source in respect to Anishinaabe.
I stand corrected. There, I guess there's one.
And of course, there's Donald Brown's book on human universals.
Okay, we'll get to that. So there's two. Okay.
There's also Edward Benton Benai, the Mishomi's book.
Sorry, what,
That's
Footnote?
footnote 49, that's I suppose I mean, it's not really a scholarly work, but it's again, I have to refer to it because Dr. Driven cites it.
okay, so Dr. Driven cites it. You don't rely on it, do you?
I respond.
Right.
Uh,
By the way, keep in mind, my question was in respect of trying to understand the Anishinaabe culture in 1850. You would agree with me that Donald Brown, writing in 1991, didn't write about the Anishinaabe in 1850. You'd agree with that?
no, Christopher Bexey, on the other hand, does.
Yes. Would you agree with me that Donald Brown in 1991 was not writing about the Anishinaabe culture in 1850?
I agree with that.
Thank you. So when I said that there was one, and you pointed out Christopher Vesky, there was one, all right. Is there anything else you want to let us know about?
No, I don't think so.
All right. So my apologies for not seeing the one site in all of your work that is a secondary source involving the Anishinaabe culture in 1850. Am I also correct, sir, that in your two reports, other than the three citations you mentioned, there is no use of any scholarly articles or literature that might inform us or inform the court or inform you about Anishinaabe intentions, understandings, and expectations and perspectives?
No,
You agree with me?
yes,
Thank you. And would you agree with me that in your two reports, other than the three that footnotes we've talked about, you did not make use of any scholarly articles that might have informed you about European or pre-Canadian or settler society?
Yeah, I did not find that necessary to the task I had.
And we can say the same thing for European or pre-Canadian or settler culture, perspectives, understandings and intentions in 1850 or thereafter. Would you agree with that?
Yes,
Thank you. I'm going to suggest to you, sir, that your report is aptly titled as a historical report. What it says. You agree with that?
yes,
Would you agree with me that it's not an ethno-historic report? It's just a historical report.
no, I would disagree with that.
Now, last week, you talked about a fellow by the name of Bruce Trigger.
Yes,
You know him?
yes, he was my mentor at McGill and my PhD dissertation advisor.
I want to show you a book of excerpts of a book of his, which you will find at tab 3. Now, this is part of exhibit 1-1678. Now, I just realized over the weekend that 1678 is only a couple of pages of this document, and I went on the internet and got some more pages. Do you recognize the chapter 1 that I have taken off the internet as Bruce Trigger's book?
Yes,
Okay. And I take it you have a lot of respect for Mr. Trigger?
I spent 8 years in close contact with Dr. Trigger, and I'd say we had a mutual respect. We disagreed on a lot of things and agreed on a lot of other things.
Well, maybe I can see if you agree with some of the other things some of the things he wrote about. I understand that this gentleman was well respected and he passed away from cancer much too early in 2007, I believe.
Yes,
Do you know how old he was at the time?
I don't recall.
All right.
I mean, but he was a generation beyond mine.
Okay. At page 13 on the 3rd line, I want to read something to you and see if you agree with it.
You're talking about
Page
the
32.
the
I
original-
apologize. Page 32 of tab 3. And again, 32 is at the bottom. It's page 13 of chapter 1. But it's page 32 of the compendium.
yes,
And the 3rd line from the top, first complete sentence says, only the anthropologist's understanding of Indian life can provide the background needed to assess the behavior of the Indians as it is recorded in historical records. You see that?
yes,
So you need,
Sorry, didn't catch up.
Yeah.
32,
compendium page 32,
got it.
chapter 1 of Bruce Trigger's work,
Thank you.
and the 3rd line. So you need to understand Indian life to understand historical records, correct?
yes. This is his work on the 17th century Wendat or Huron, as they used to be called. So what he's saying here is that you need to have an anthropological understanding of the Jesuit of the actions that are explained in the Jesuit Relations, which is what this whole work is about. It was a history of the Huron people based on 17th century ethno-historical documents produced by the Jesuits and Champlain and Gabriel Sagard. And so you need to have an anthropological perspective. Otherwise, you get lost in the ethnocentric and Eurocentric views of the Jesuit language. When they're because they're the ones giving us the information on these people. So you need to have that anthropological perspective.
Sorry, my question, I guess maybe I'll be more direct. Would you agree with me that in order to understand the RST Anishinaabe behavior as it is recorded in historical records, you would need to understand their Indian life to provide the background? Would you agree with that? You see what I've done,
Yes.
I've taken his quote and tried to apply it to the 1850 Anishinaabe.
Yes, I think as a general rule that's the case.
All right, and in the very next paragraph, starting with the words, for example, which are 8 lines down from the excerpt that we just saw, Mr. Trigger says, for example, knowledge about the behavior and customs of modern Indians, even those who have been greatly assimilated into the dominant culture of North America, may provide information about personality types, religious beliefs, and in some cases, social and economic practices that is of value for checking and interpreting historical accounts of these people. That's what he says. I understand it's in relation to the Hurons of many, many years ago, but would you agree with me, sir, that that same statement rings true for the Robinson Superior Treaty of Anishinaabe of 1850?
No, not necessarily. In some cases, yes, and in some cases not. For instance, as you correctly say, this sentence was written in the context of Iroquoian cultures, of which the Huron were a part. And what he's addressing here, the example that he is actually addressing, involves specifically gleaning information from 20th century Haudenosaunee medicine societies and beliefs about creation, which can be projected back in time methodically into the 17th century.
Yeah,
Because
but I'm
we
not
have-
asking about this.
Yeah,
what-
because we have a record of that, and that's a well-known phenomenon. It in ethnohistory we call it upstreaming. You start with the modern indigenous culture and you try and upstream against the flow of history these modern belief systems and practices and so forth, until you reach a point in the historical record where they're no longer visible. We have that in place for certain characteristics of Haudenosaunee culture. It's not so much true of Anishinaabe cultures. There's a limited extent to which it's true, but you cannot generalize that. You know, it's not a matter of simply going and looking at the behavior and customs of modern Indians, as Dr. Trigger puts it, and then projecting it back and interpreting historical accounts. It's not that easy. He's specifically referring here to upstreaming, and that is a very contentious subject because there's only some aspects of human culture that you can do that with.
Maybe I can try and put it in the inverse. Am I correct then in understanding that your position and understanding and your opinion is that knowledge about the behavior and customs of the modern Anishinaabe in the Robinson Superior Treaty area provide no information that would assist in checking or interpreting historical accounts of those people? Is that your position?
No, that would not be my position. My position, as I articulated it in my second report, is that the means or methods or methodology that Dr. Dribbin uses to affect that result is flawed. I'm not suggesting that there's nothing in modern Anishinaabe culture that can't be traced back in time to the 19th century. That would be an absurdity. Every culture
No,
is a
no.
combination of change and continuity.
Would you agree then, sir, that some behaviors and customs of the Anishinaabe in 1850 could provide some information to assist you in checking and interpreting historical accounts of the RST Anishinaabe?
Well, if I was given examples, more specific examples, I would certainly consider it. I would never a priori, say that there's nothing in modern Anishinaabe culture that is not going to illuminate the record. But, what is the specific task that we're
The
trying to
task
do?
is to try and understand what happened in 1850 and what their expectations and understandings were in 1850. Is there anything, in your opinion, one can learn from the modern Anishinaabe in present days?
I don't know, perhaps there is, but Dr. Dribbin has not provided that link. And
Didn't ask
My
about
role-
Dr. Dribbin, I'm asking you.
my role was to respond to his specific efforts. It wasn't to try and reconstruct entirely the Anishinaabe worldview of 1850.
I'm sorry, sir, that's not quite fair. When you did your work on your just demands report,
Yes.
last week you told us you had to get into the understanding of the Anishinaabe to answer the question about the Crown's conduct.
No, what I said was I needed to understand how the Crown understood the Anishinaabe perspective through their petitions.
Sir, if the Crown needs to understand the Anishinaabe perspective, then you're engaging, and you told your council this, in an ethno-historic analysis of the Anishinaabe in 1850. You're saying you didn't do that?
No, I am saying that my Crown conduct report had as its core intention a reconstruction of the Crown's understanding. And to the extent that the Crown's understanding was informed by Anishinaabe petitions, I needed to read those petitions and place them in the record. And my Crown conduct report was not about Anishinaabe conduct.
So we should just tell the judge to ignore your opinions about the Anishinaabe understandings and perspectives?
No, now you're turning to the second report.
So in the second report, then, you did look at the Anishinaabe understandings and perspective and look at what they understood. Is that right?
No, I responded to the manner in which my learned colleagues tried to reconstruct those perspectives and address their methodology.
Well, I'm not going to let you off the hook on this one. Sorry. You agree with me then, sir, that there are some behaviors and customs that might have provided information to help you check and interpret the historic accounts in the written record. Do you agree with that? I'm not talking about Dr. Drippen, I'm talking about you.
Yes, I would. My view is that you try and get any and all information that's germane, including information that dates to modern times.
Thank
I have
you.
nothing against, that's why, I have nothing against the use of oral histories or oral traditions related in modern times to try and illuminate the past. So I've never been of the position that the modern era is irrelevant to reconstructing the past. I've never had that position. I would never say it again in court today.
Thank you. But you didn't look for it.
I have not seen it.
Did you look for
If
it?
it hasn't been in the record,
Did you look for it, sir?
well, where am I to look? I mean,
Ye-
Just a simple,
yes, no, I did not. I mean, that's not something that these two reports required.
Wouldn't have been helpful to consult secondary sources on Anishinaabe culture, perhaps? You don't think that would help?
This is not a requirement for the two reports that I wrote.
Right. Moment, please. Can you go to page 35 of the compendium, which is page 16 of Mr. Trigger's work? And the second last paragraph, the third last line, starting with the words history, comma, or that of any non-literate people. You see that?
What page was this on?
Page 35, it's chapter 1, page 16.
Yes,
And the second, I think Ms. Lewis will highlight, I don't know if you can highlight it, Ms. Lewis. You see that paragraph there, right there, the whole, starting with in either case?
yes,
I think the point that Mr. Trigger is trying to make here, as detailed knowledge of a culture as possible is required if the history of that group is to be understood. Do you agree with that?
yes.
Let's go over to page 17. In the middle of the page on page 17, starting with, there's the word all, comma, the ethno-historian must not fall. Right? And starting with the sentence of the word above all, which is above.
Yes, I see that.
Yeah, okay, I want to read that to you.
Yep.
Above all, the ethno-historian must not fall into the common anthropological error of assuming that a written document necessarily means what it says. Ambiguous wording, mutilated or ill-copied manuscripts, improperly set type in old printed books, or the editing of manuscripts in such a way as to distort their original meaning all present serious difficulties. Do you agree with that?
Absolutely.
Thank you. And he continues, where editors intervene between an eyewitness and the earliest recorded account of what he's seen, as in the case of Jesuit relations, the possible bias of these editors must be taken into account.
Yes,
You agree with that? Do you agree with that?
absolutely, that's.
He
part of the
continues,
training.
even when what are purported to be Indian speeches survive, they must be treated with caution. Period. Filtered through translators, the recorder's incomprehension, and the general tendency of European authors of the time to embellish and to fabricate whole addresses. It is not always certain that such sources are reliable. Period. All of this makes historical research a painstaking affair. Do you agree with that?
Yes, I do.
Thank you. Turning then to page 25, and this is the last 25 of Mr. Trigger's work, which is page 44. In the middle, you will find the following quote under, it's right in the middle, starting with Indian -white. There you go. Oh, we're going to start from I want to read this to you. The first sentence of that line. It is also clear that we can learn far more about the general background and personal motivations of the Europeans who are mentioned in our sources than we can about the Indians. Do you agree with that?
Yes, I do.
He then continues, if unchecked, the ethno-historian's natural tendency to make the maximum use of his data can turn the best intentioned Indian history into nothing more than a restudy of European colonization.
Yes,
Do you agree with that?
yes, I do.
Have you ever heard of things called unconscious bias?
Yes, it's something to be avoided. But
What is it?
It's difficult to avoid.
Yeah. Can you tell us what it is?
Well, bias of any sort, any kind of cognitive bias is something that we're trained to avoid, but unconscious bias is difficult to avoid because of its very nature and definition as being unconscious. So it's one that is difficult to avoid, but we have to be attuned to it and try and understand that we're all subject to it in one way or another.
Would you admit to you being subject to unconscious bias in it to any degree?
I think everyone is subject to unconscious bias, including myself. But as I said, we are trained to deal with cognitive biases to the best of our abilities. And that minimizes the risk, but does not completely. And we can never overcome unconscious bias. It can be identified. And once you identify it, then it becomes manageable. But if it hasn't been identified, then it's a debilitating condition that affects all of us.
I wonder if we could turn to discussing your assumption number 2. Am I correct? I think I'm correct in saying that. Hold on a second. I noticed the time. Should we take a break?
How are you doing?
I'm doing fine.
Okay. Let's take. Let's take a break then, 15 minutes.
Yeah.
This court will recess for 15 minutes.
Dr. Von Gernert, I wanted to turn to your assumption, what you call assumption number 2, and just to be clear, once again on the record, that assumption number 2 is the Court of Appeal decision where you are supposed to be trying to assist the court in ascertaining the views of the Anishinaabe and the Crown about sharing the wealth in the treaty territory on the basis of there not being any cap. Is that fair?
Yes,
Now, if you go to your slide deck that accompanies your perspectives report and go to page 8. And you say, once assumption number 2 is adopted, we enter a realm of speculation at a high order of magnitude in respect of the parties' understanding about sharing. You see that?
yes,
Now, I'm not going to ask you about Dr. Dribbin. I'm asking you about your opinion. I want to make sure that the court can understand what your opinion is. Would you agree with me, sir, that what you have to say, this is your opinion about assumption number 2, is speculation at the highest order of magnitude in respect of the parties' understandings about sharing?
yes,
And would you agree with me that speculation is entirely unhelpful to the court?
yes.
Thank you. Can we go to page 34 of your perspectives report, please? At page 34, which is, and this is still in your section about assumption number 2. You say that if the Anishinaabe expected a generous share, that they would not overwhelm the Crown. Let's see. Sorry, let me see if I can find it. At the bottom of the second last paragraph, what you say is, my own opinion is that if there was a common intention, it was more likely to have been informed by assumption number 1. That might not have been the preference of either party, but that was the compromise agreed to. You see that?
I'm just looking for it.
Yeah.
Page 34.
Page 34 of the report, the
Right.
last complete paragraph, the last 3 lines.
Thank you.
You see that?
Yes,
So your assumption number 2, which is supposed to be based on accepting the Court of Appeal decision, invariably comes back to assumption number 1. Is that true?
no, what I'm talking about here is that if Dr. Dribbin is correct about the Anishinaabeg view, there was, in my view no common intention, because my understanding of the Crown understanding is in line with assumption number one. So if there was any common intention at all, it was more likely to have been formed by assumption number one. I'm not saying that there, that there was a common intention, but I am, let's put it this way, my level of certainty is quite high when it comes to the Crown understanding. It is not as confident and high when it comes to the Anishinaabe attention. So this whole paragraph is now referring back to conclusion number 4 of Dr. Driven, who says there was was commonly understood. And so I take issue with that. And do not see how there could have been a common intention. If Dr. Driven is correct about the Anishinaabe view, then as he articulated in the first 3 conclusions he gives, and if I am correct about the Crown intention, then I'm afraid we don't have a common intention. That was my point.
Sorry, I think you read more into my question than I had actually asked. It sounds to me when I read these words,
Yes.
this might not have been the preference of either party, but that was the compromise agreed to. That compromise agreed to is assumption number 1. Correct?
Yes, if there was a common assumption, then that is what it was. It was a compromise that was agreed to at the time of treaty.
But your opinion in this section is not about assumption number 1. It is about assumption number 2.
That's correct.
Assumption number 2 is that there is no cap. But in assumption number 2, where you say you are assuming there's not a cap, you conclude, almost conclude, towards the end of your conclusion, that the facts are that what they agreed to was assumption number 1.
No, this is not in a section under assumption number 2. This is in a section in which I address the opinions on the views of the other experts. So I am addressing here those 4 conclusions that Dr. Driven comes to. And more specifically, his conclusion number 4, in which he says that the Crown officials with whom the Anishinaabe interacted during the treaty-making process understood that the Anishinaabe held these views and acted accordingly. And the views that he's talking about are the views expressed in the previous 3 conclusions.
I see. So would you at least agree with me that Dr. Driven was operating under the assumption that the Court of Appeal was correct?
Of course, I would agree, since I heard him testify at stage 1, and both he and I have testified throughout consistently. So of course he views the Court of Appeal decision as correct in his mind.
Perhaps we can move on to page 31 and 32 of your report. This is referring to your opinion. It's not about the opinions of the views of other experts.
And this is exhibit 50 in perspectives.
We are
report.
now looking at exhibit 50, the perspectives report, page 31, last paragraph, where you write, at the end of the day,
I'm sorry, where are you?
I'm at page 31 of exhibit 50, last paragraph. I'll wait for you to get there.
Page
Page 31.
31. Yes,
You write, at the end of the day, it is fair to conclude that there is no such thing as a single Anishinaabe perspective that can be enlisted in the service of the task at hand. See that?
yes.
Now, first question, can you tell the court whether there is any Anishinaabe perspectives at all that can be enlisted in the service of the task at hand?
Well, of course, there are, Dr. Driven points to several.
Okay, thank you. At page 32, you opine that, in my estimation, oh, sorry, I should locate this for you. It's in the second paragraph. Third line, in my estimation, have you found it?
Yes,
In my estimation, no amount of anthropological, ethnohistorical, or other evidence of Anishinaabe principles, perspectives, understandings, and expectations is capable of illuminating the issue with the tolerable level of certainty that is required for such a project to be of assistance. See that?
yes.
A couple of questions about that. What is the issue that you say needs to be illuminated? I want to be clear about what you're intending here. What's the issue?
Okay, so the issue is I articulated on page 7.
Yes,
I understand that the need to have experts address, quote, the potential role of Anishinaabe principles and perspectives, end quote, or their, quote, understandings and expectations in relation to sharing under the treaties, end quote, arises from a specific task of the trial judge that the Court of Appeal says, quote, is to determine what kind of sharing the augmentation clause requires and what increase is necessary in the annuities to fulfill the treaty promise, end quote, or more particularly to, quote, determine the form, level, and aim of the sharing that the augmentation clause requires, end quote.
that's your answer.
Yes,
Let's move to the next question about the quote I read to you at page 32, where you talk about a tolerable level of certainty. And I want to understand what you mean by what level of certainty is tolerable.
I don't think that there's any anthropological, ethnohistorical, or other evidence about these principles that will give you a number between 0 and 100% share, or what I call the excess share, or the shareable excess. So given that you can't come up with a number. I mean, perhaps there is another way of this court or someone determining that level, but it can't come from an ethnohistorical exercise. Which is why, I said that in that same passage that it's best resolved by having the parties who have an interest in the shareable excess sitting down and hammering out an agreement through negotiation. I just don't see how an ethnohistorical approach to this can give you the tolerable certainty to come up with a a number.
So,
Mr. Shachter,
Yeah.
I offer this to you as a question, and that is, do you see the only answer to the question is answerable by a number?
Well, perhaps it's. No, I mean, but if that is,
Well, no, but that was my question.
that was where I
No.
was going. to.
Sorry, I'll leave it to you.
No, I'm trying to understand when you say tolerable level of certainty, you're looking for a particular exact number. Is that what the
well,
problem
if
is?
that is the task, and perhaps it isn't. I thought that at the end of the day, there has, a quantum has to be decided on. But if it's not, it's still. I mean, how much of the shareable excess is to be shared? That's still a question. And even if it's not a number, I don't see how any kind of anthropological or ethnohistorical evidence can contribute to that solution.
Again, we might be talking at cross purposes, and I'm going to spend a couple moments to try and clear it up.
Sure.
When I read the words tolerable level of certainty, I was reading, and perhaps I was incorrect, but I was reading that you were trying to explain to the judge and explain to the reader, explain to the court that we can't get to a balance of probabilities, or we can't get to 99% confidence level. We can't get 100% perfection. And that's what I understand the tolerable level of certainty you were talking about. Not about, we can't know for sure the exact number, but that we can't come to certainty. Did you mean 100% certainty? I agree with you. I mean, I don't think anyone would disagree. You can't come to 100% certainty. But what did you mean by a tolerable level of certainty? Were you thinking some sort of more likely than not? I mean, what were you thinking?
Yes, so. As I indicated, there. Once you have a task of trying to determine how much of an open-ended shareable excess there is or might be, it's very speculative to try and reconstruct what the intentions were at the time of 1850. You're never going to be certain about it, but I don't even think you're going to be anywhere near what is a tolerable level of certainty, because as you said, it's all about probabilities, right? It's not about certainty. It's about probabilities. But you don't, the ethnohistorical and anthropological record and data is just simply not going to allow that.
It's not going to allow certainty. I can accept that, but if certainty is 100%,
It's not.
well, what is certainty? 90%, 50%, 20%? Is there a percentage that you would put in your professional opinion? Or like, what is it?
No, that's like the argument of the beard, right? At what point does a man go from a clean shave to a full beard? You can't have
Is this a known problem in anthropology?
It's a known philosophical
Okay.
axiom. The argument of the beard, at what point does it become a beard, right? So a tolerable level of certainty is one that's going to give you a just solution. And I don't know how that can happen based on purely ethnohistorical reconstruction of events.
Right. Okay, so let's work with that. So a tolerable one is the one that gives a just solution. Can we work with that?
Or a solution that's acceptable to all the parties.
Well, let's suppose a judge has to decide what a just solution is,
Right.
right? But your point is that you can't simply base it on ethno-historical, anthropological, or other evidence of Anishinaabe principles, perspectives, and understandings. The judge has to look at other things too. Is that your point?
Yes, I would think so.
Okay. Let's turn to page 37 of your perspectives report. And I think maybe if we look at slide 15, I'm sorry, Ms. Lewis, slide 15 of your perspectives report. So we're looking at exhibit 53, page 15, slide 15. This is where you assert that Dr. Dribbin's opinions on sharing are A, not based on ethnohistoric evidence, and nor you say are they based on a sound methodology. You see that at the very first bullet point?
Yes,
Okay. Now, would you agree with me that Dr. Dribbin bases his views on sharing based on what he opines is the culturally significant kinship relationship between the Crown and the Anishinaabe in 1850?
that's one of the factors that he refers to, yes.
Would you agree with me that that's an ethnohistorical approach?
It may be an ethnohistorical approach, but it's not ethnohistorical evidence in the sense that it's rooted in an actual document. It's based more on general principles of kinship, which I don't have any issue with.
Sorry, my point. Sorry, did I cut you off? Was there anything else?
No, go ahead.
Okay. My point is, I understand you disagree with his conclusions. And you may also believe that he's misunderstood Anishinaabe culture. But I take it you don't seriously. You're not telling the court that in your professional opinion, his views are not based on ethnohistoric evidence. You just disagree with him.
Well, I don't dispute that he is engaged in an ethnohistorical exercise, but the actual documentary evidence that suggests his understanding of how the Anishinaabe understood words like father and children is not based in any documentary record that I've been able to find.
Well, I think one of them we talked about earlier. It's the Ojibwe of Barons River by Irving Hollowell. We went through a number of his passages. He relies on that. Is that not ethnohistoric evidence?
No, that's an ethnographic description by an anthropologist working in the field in Barons River and saying, you know, these Anishinaabe have a similar kinship system as other indigenous peoples.
So what in your mind counts as evidence of ethnohistoric evidence? Perhaps Dr. Dribbin going out into the field and living among the Ojibwe, does that count?
No, what I'm referring to is any documentary evidence from the period of 1850 or after, in which Anishinaabe peoples are actually expressing an interpretation of why they use terms like father and children and how they're used in the sense that Dribbin understands it. So Dr. Dribbin, has a certain view of how they would have interpreted their use of the terms, of these kinship terms. And that, I just don't see the ethnohistorical evidence for that.
I think I understand. What you're saying is that you couldn't find any documents in the record in phase 1 or phase 3, or suppose phase 2, that support Dr. Dribbin's conclusions. Is that fair?
Yes, there's no shortage
Okay.
of examples of the use of father and children and white children and red children and so forth. That they're ubiquitous in the record. But there's nothing in the record that actually points to Dr. Dribbin's interpretation of how the Anishinaabe would have understood those words in
Yeah.
their context. of
I'm
use.
going to suggest to you, sir, that that's your interpretation of the evidence. It's not Dr. Dribbin's interpretation of the evidence. Would you agree with that?
No, I'm not certain what you're asking.
Well, you're saying, you've just told the court and me
Yes,
that the evidence in phase 1, the evidence in phase 3, all the documents don't support Dr. Dribbin's interpretation. And I'm suggesting to you that that's your interpretation of those documents that make you say that. It's just a difference
yes,
of interpretation. It's not that there's no evidence. You're saying there's no evidence because you disagree with his interpretation of it. There's quite a difference there. You understand that?
yes, I disagree with his interpretation. The evidence, of course, is in the form of the usage of the kinship terms. The evidence is not in the form of how the Anishinaabe at the time would have understood that usage.
Well, okay, that's your opinion of what the evidence is.
That's my understanding.
Okay, thank you. We can leave it at that.
Could I just ask one question?
Yeah, of course.
You said, where's that Hallowell?
It's
material.
at tab 2 of exhibit Q,
Right.
and you're looking for page 16 of the compendium, I suspect.
No, I
Oh.
that's good enough. Thank you. So, sir, can you describe the geographic area of this study? And did you say northwestern Ontario
Well, the
and
Barron,
Manitoba?
yeah, the Barrens River, Anishinaabe were, where Hallowell did his field work was at the extreme eastern end of Manitoba, close to the Ontario border. But of course, the Anishinaabe peoples traveled on both sides of that border. So the Anishinaabe were actually in both what is now Ontario, northwestern Ontario, and western Manitoba.
And do I recall from earlier evidence that they would have understood one another's language, they would have spoken similar language?
Yeah,
Ojibwe?
these are now much more northerly Anishinaabe peoples, but they share a similar culture.
And so that's what I thought. And so you say if there's a study on one side of the political border or on one river
Yes,
watershed, the Barrens River, that there's nothing you can learn from the people, I don't know, could be who possibly share the same hunting territory, language. There's nothing to learn.
yeah, I didn't suggest that there's nothing to learn from this, of course. Hallowell's work, on kinship, the importance of kinship, of course, and we don't need Hallowell to say that kinship was important for the Anishinaabe and.
Well, I don't think that was the
Ontario.
evidence. I don't think
Right.
there was more than that. There was using, there were other questions, but I thought it was your evidence that you can't take the Hallowell study to say anything about the RST First Nations in 1850, their understanding, and or in this last series of questions
and answers with Mr. Schachter, you said there is nothing in the record.
Yes, well, this is the
That helps.
this is the 1930s.
Right.
And Hollowell is,
There may be many different reasons why you distinguish it. I'm just
Yes.
asking for your conclusion. You say it can't help, or it's not evidence
no,
that one would use?
no, don't get me wrong. The Hollowell comments on the importance of kinship among Anishinaabe peoples, which is unsurprising, of course, is applicable to more than just the people that he studied. It is, part of all indigenous peoples, not just Anishinaabe. The importance of kinship is a very important part of their lives. But what Hollowell does not inform us, and what we need, is what particular importance or interpretations did the Anishinaabe give to their use of kinship terms like father and children and white children and red children in treaty making or formal discussions with non-Indigenous peoples. Hollowell doesn't inform us about that at all. Right, he just tells us, kinship's important and it, it's used in this way and that way. So my evidence is not that Hollowell can't illuminate Anishinaabe kinship. I mean, I've used Hollowell to illuminate Anishinaabe social organization.
I think, thank you. I'm
Doc-
sorry, go ahead.
Yeah, Dr. Von Gerner, the second thing that you complain about Dr. Dribbin is that he does not use a sound methodology. And I want to make sure that the court gets the full implications of your criticism. Firstly, and I think we're looking at around pages 34 to 35 and slide deck 15. You say that his methodology is flawed because he looks at what he understands to be the facts of history. We disagree with him on that, correct? You would disagree with his interpretation of the facts of history? Is that true?
I disagree with his method of arriving at history.
Okay, just let me, so you don't necessarily disagree with his interpretation of the facts of history, or you do?
Well, you'll have to give me a specific example.
Okay, let me try it this way. I understand that Dr. Drippin's methodology was to look at the historical record, take what he knows about ethnohistory, take what he knows about being in the field, put it all together, and in his professional opinion, come up with an opinion after examining the ethnographic record. And then he comes up with an opinion that the Anishinaabe in 1850 had a particular view that is common to them when they entered into the treaty. Is that a fair assessment of what he's done?
Yeah, my assessment of what he's done is that he's engaged in circular reasoning, because he starts with a particular, moves to use it to illuminate, or I should say he starts with a specific, then moves from the particular to make generalizations, and then uses the generalizations to try and illuminate what happened in 1850. And to me, that is a flawed methodology.
Well, I'm going to suggest to you that with respect, that is not a flaw of logic. It is not circular reasoning, and you've described it improperly. Let's try and unpack it, okay?
Okay.
I suggested to you that what Dr. Dribbin did is he used his expertise to try and ascertain if there was a common, an Anishinaabe perspective in 1850 that he could apply to the problem at hand, which is their understanding of what their share might be. So he comes up with some cultural attributes. Is that fair?
Yes, and underlying that is the premise that these cultural attributes are inherent to Anishinaabe culture.
Well, you can disagree with him with disagree with his conclusions without labeling his conclusions unmethodologically sound. All he's done, all I've asked you so far is he's come up with an Anishinaabe perspective or cultural understanding. That's not a methodological error.
Well, it is. Right from the beginning, it is, because the generalizations about Anishinaabe culture are drawn from specific cases in time and place. And in order to sustain such a generalization, you then need to account for the instances in which the generalizations do not hold, and he's never done that.
Excuse me, Dr. Von Gernert, if your interpretation is correct, then no people can ever have a culture because everything's just individuals. Do you
No.
agree with that?
No, absolutely not. That's not what we're talking about.
It sounds like what we're talking about.
But, he titles his report, happiness. And, obviously, if that is an Anishinaabe cultural attribute, as opposed to something that all humans strive to, then that's of little help in determining what's an Anishinaabe culture, right? It's not, it's fine to try and use generalizations to illuminate specific cases, if you're confident that the generalizations will hold everywhere in all times and places, which is why Treaty 3 is important. Treaty 3 is not important for the reasons that you and I had a discussion about earlier. Treaty 3 is important because if his generalizations hold, then it should apply to all Anishinaabe in all times and places.
And now we're talking about the generalization about they generous but not overwhelmed.
Yes.
Well, let's just jump into that for a moment. What in the record makes you suggest that the Anishinaabe in 1850 had the intention to overwhelm the crown?
I don't argue that, and I don't agree that that's even a consideration. I'm here replying to Dribbin. Dr. Dribbin says that the Anishinaabe have some kind of propensity to ensure that the crown is not overwhelmed. That there's generosity, but not in an amount that would overwhelm. And so if that is true, that's a testable proposition. And if it's true, why does it not apply in cases like Treaty 3?
Well, just in Treaty 3, did they enter into a treaty that overwhelmed the crown? Did they?
In Treaty 3,
Did they enter into I want to answer to the question. Did they enter into a treaty that overwhelmed the crown?
in the end, no.
Thank you. What evidence do you have, sir, that what they asked for did in fact overwhelm the crown, other than the treaty commissioner saying?
Your Honor, my friend is shouting at me. Last answer probably for that reason.
Perhaps we can go back. Did you want to finish something? I apologize.
It's
Dr. Von
the end
Gernert?
of a hot day. I didn't think it was that harsh, but maybe we're all.
I'm not trying to be harsh. I'm just
Okay.
trying to I apologize if my voice sounds raised. I am not in any way trying to be disrespectful at all.
No, I didn't take it that way.
Thank you.
And I appreciate the strength of your cross-examination.
So was there anything else you wanted to add about the point before I moved on?
Well, if the Anishinaabe worldview is infused with this notion that when they ask something of the crown, they want the crown to be generous, but they don't want to overwhelm the crown with too big an ask, then why in 1869 did they come up with a list of demands that, you know, did overwhelm the crown, literally? To
Are we
the
talking
point
about
where-
Treaty 3 now?
Yes, to the point where it was utterly rejected. The second time they produced the list in 1873. And you know, it was only after difficult and protracted negotiations that Morris and the Treaty 3 Anishinaabe finally came to terms on a compromise. The Crown had offered $3, the Anishinaabe had wanted 10. They eventually settled on 5. And so,
But so, Dr. Von Gernert, we've already established that the Treaty 3 Anishinaabe ended up entering into a treaty that did not overwhelm the Crown. You agree with that?
yes, very reluctantly.
They entered it very reluctantly, or you agree with me very reluctantly?
No, they entered it, they entered into it very reluctantly.
All right, thank you. Now, had they asked for $1,000 per person and not $10 per person, on what evidence would you say in that hypothetical that they would know that they were asking for more than the Crown could give?
Oh,
You can't.
well, make no mistake, the Anishinaabe knew perfectly well that they were not going to, you know, at first, when they provided this list in 1869, when they came up with it, maybe then they thought, well, maybe we'll get this. But by the time they presented the list again in 1873, they had already gone through 2 years of negotiations, and they knew perfectly well that this is a non-starter.
Well, with respect, sir, wouldn't you agree with me that simply because the person on the other side of the negotiating table says it's too expensive, doesn't answer the question as to whether or not it is too expensive? Or put another way, or sorry, wouldn't you agree with that? Let me just start with that. You want me to rephrase the question?
Yes, please.
Yeah, I think that's fair. Just because the treaty commissioners in Treaty 3 said that's too much money to ask, doesn't actually mean that it would overwhelm the Crown. Would you agree with that?
No, it did overwhelm the Crown. I mean, how else, what other words would you use to describe it?
Let me
I
put
mean,
it this way.
there's the difference is so huge between that list. And I mean, it was literally, you know, over $100,000 per annum more than what the Crown was paying all of the pre-1850 treaties combined.
That doesn't matter. What matters is whether the Crown could afford to pay that extra $100,000. And here's the proof. The proof is in the pudding. Would you agree with me, sir, that since 1873 and Treaty 3, the Crown has benefited more than $100,000 in wealth derived from Treaty 3 per annum?
That's almost indisputably true.
Yes. So it didn't overwhelm them.
Well, but that
crazy.
was, but that figure is your modern reconstruction with hindsight. At the time, the Crown could not afford that and did not afford that. And when they settled on 5, that became, again, a further precedent to have all the other treaties for the same amount. What would have overwhelmed the Crown was the ask that was made, which was so far in excess of anything that had ever been done before, that it was a non-starter for the Crown. So,
Do you mind if I just ask it this way? You take the position in your response to Mr. Schachter's question that they would have known it would overwhelm the Crown.
not the first,
Because, well, it doesn't matter first, second, third time. If they would have known that the request overwhelmed the Crown because it was so soundly rejected. You say that's the evidence of their knowledge.
no, the evidence of their knowledge is that when they first came up with the list in 1869, it may have seemed a reasonable amount to them. However, they then went through several years of negotiations at which it was made absolutely crystal clear that the Crown was not going to provide them with more than a $3 annuity.
Okay, so
And
that's partly where I'm trying to get
Yes,
to your understanding of their knowledge.
yes, so,
So you say their knowledge of the other party in the negotiation saying, this is a non-starter, it's going nowhere, too expensive, whatever it is. That is that the facts that the people on the other side of the table have been giving them in a negotiation. You say that is evidence of knowledge, that it would overwhelm the Crown.
yes, and from the Crown's perspective.
No, I
it
just
did,
wanted to know from the Anishinaabe
right,
that is their knowledge, therefore.
yes.
Okay.
I don't think I need to ask any more questions on that point. I do have a couple more questions. It's 4:30. I'm gonna go through perhaps
It's
one more area, if that's
It-
okay.
actually not a good day to go passport.
Then I will stop now.
Okay. Thank you very much. I hope it's an ending now is not does not become a problem for tomorrow, but
No,
We'll
we're
deal with-
still on track to finish tomorrow. Yeah.
okay. All right, thank you very much. We will end the day now.
Oh yay, oh yay, oh yay. The sittings of this court are now concluded. Long live the king. Thank you.